everyone. Welcome to join us today. And my name is Huang. I am the Senior Tax Manager at Andersen LLP in the Vancouver office. I'm very pleased to welcome everyone to join this interactive section. Today we are focused on cross-border tax and immigration planning for Canadian family moving to expand their business and to the U.S. Right now, let me to introduce our four speakers. On my right side is Johanna's Huang. He is the financial advisor from Raymond James, and this one is This is Asif Abdullah. Yeah, he is the partners from Thorsteinssons. These beautiful girls, Shan Lu, she is the director from Andersen, and the last one, let me see, Harley Friends from Cascades, and she is the immigration lawyer, like his home office in Seattle, right? Bellingham. Okay. Yeah. Before we start, there's some housekeeping items I want to mention. The first one is we have the freshmen are available through our section, so please feel help yourself to any time during the section. And the second, our washroom is on the right side of the hallway. Someone already asked me where's the washroom, so like right side of the hallway. And the third is please turn off your cell phone to minimize disruptions. The fourth is we will have the dedicated Q&A section at the end. But feel free to note your questions as we go. Okay. So finally, there's a quick disclaimer. So this section, this discussion is only for general information purposes. It's not intended to provide any professional advice for specific to any personal. So if you have your own issue, please, we recommend you contact your own advisor before making any decision. Now, let's get this started. And so let's jump into the case study, and then we will meet Smith family. And next, we should welcome Holly to walk us through the fact pattern, and Johanna will provide the summary about the current objectives. So welcome.
Thanks, Francis. Can everyone hear me? Okay.
Yes.
So yeah, I'm Hallie. I work with Cascadia Cross-Border Law in Bellingham. As Francis mentioned, we're kind of structuring this conversation as a case study based on kind of like a typical situation that we see a lot of with a Canadian family wanting to relocate and expand their business to the States. So in this particular case study fact pattern, the family consists of all Canadian citizens who are also Canadian tax residents, so they're living full-time in Canada. They're Joe and Kevin, they're a father and son business duo who established a thriving home security business called SecureCo that manufactures and sells security products to retailers and security manufacturers in the U.S. and worldwide. The founders include Joe Smith and his spouse Susan Smith, who are in their 60s, along with their son Kevin Smith in his 40s, and Kevin's spouse Claire. Kevin and Claire have 4 children. The children range in age from about 7 to 16. And business-wise, the company does a lot of trade with the United States, supplying their security sensors for these companies' products for sale in the US and elsewhere. And the owners, so primarily Joe and Kevin, have considered incorporating in the United States and opening a US location to grow their presence and expand their capacity to supply their product to their US clients. But they're not quite ready to do that yet. And they still are in the stage where they want to explore the business and the tax implications of having a US business presence. So I'll turn it over to Johannes for a little summary of their goals.
Yeah. So I might say mom, dad, kid. I tend to think of families as from a family relationship standpoint. So you've got the kids, and in my mind that's Kevin and Claire. Right? They're in their mid-40s, and they're thinking about moving to Hawaii and purchasing a home. They plan on living in Hawaii for at least a year. And after a year, they want to decide, do they stay in the US, do they move back to Canada, or are they going to do something in between? I think, and we have both mom and dad and the kids that are owners of the corporation as well. And they want to learn more about the implications of expanding business operations into the United States. So there's this bit of a discovery process here, is that, what should we be looking at, who should we be working with, and what are the pros and cons of expansion into the United States. And then you've also got mom and dad, Joe and Susan, that are also interested in spending time in Hawaii with their kids and their grandkids. And they want to learn about how much time they can spend in the United States and whether or not they should consult with an immigration lawyer.
Thank you, Holly and Johannes, for setting this stage. And as you heard, cross-border, this is multi-generation family with they are considered to move into the US and expand their business. Because of they want to move, and there's lots of things come from this decision. And so next step, we will going through all of the consideration, including the immigration and the Canadian and the US tax and the financial investment planning. I will pass to Holly, and Holly will talk about the immigration first before move. Just based on my experience, just keep in mind, don't go to any advisor 1 day before you move and say, I need a plan. This is you are killing them. And the one suggestion they will give, go home and pack your luggage. And yeah. But for us, we are professional. I think Holly will provide the more detail about the immigration area, and Shan and Asif will provide the Canadian and the US tax perspective before you move. And Johanna will provide some idea about the financial investment before you move. I think this is very important. So go ahead, Holly.
Awesome. Thank you, Francis. And yes, that's the most important thing is the planning stage, and giving yourself ample time to apply for a visa if you need it, and establish your tax and your financial plans. So that's something I always say, I recommend starting at least 6, ideally 12 months in advance of your planned move to figure out not only your tax and your financial planning strategies, but also how are you going to legally live and work in the US from an immigration perspective. And as I'm sure all of you have heard or are aware, the US immigration system can be quite slow in many ways, and it can be complicated. So that's what I always recommend, starting as far in advance as possible. There's 2 main routes of types of US visas, an immigrant visa and a non-immigrant visa. So when I say immigrant visa, that's pursuing lawful permanent residency or a green card, and there's a path to US citizenship with that route. When I say non-immigrant visa, that's more commonly referred to like a work visa, so a temporary status issued for a certain amount of time depending on the type of visa that would allow somebody to live and work in the US with the ultimate intent of returning to Canada when the visa's up, or renewing the visa, which is possible for many of them. So in this particular case, I'm focusing more on non-immigrant visas because that's typically where I see people start. It's the quicker way to access the United States, to be able to live and work, and business timelines. You can't always say, I want to move to the States, but let me plan out 3 years from when I'm going to have an immigrant visa, because it can take that long or sometimes longer. The non-immigrant path can get you access to the U.S. in a matter of months, and then from there, depending on how things go, and if you're liking operating your business and living in the States, you can then explore permanent residence options further down the road. But either is an option from the beginning. And something I always like to flag for people in this exploratory stage, when the business owners, for personal and business reasons, are looking at relocating to the U.S., is the types of activities that you can do in the States without a visa. So when you're just entering as a visitor, and the limited scope of things you can do on behalf of your Canadian company as a visitor. And there's a lot for Canadian business people. I mean, you can attend trade shows, you can go to conferences, you can negotiate contracts with your U.S. customers and clients on behalf of your Canadian company. You can have business meetings, you can look at real estate. So there's a lot that can be done in this stage to kind of build your foundation before you actually are applying for a visa. But it's also important to know what you can't do without work authorization. And in that case, it's certain things like managing U.S. employees, or managing a U.S. business. So if there's a U.S. business presence, that can complicate things a little bit. But as long as it's strictly international and you're not working, but you're rather doing business on behalf of your Canadian company, there's a lot of things that can be done in the starting phase. From there, especially for this family, they want to relocate. They want to move to Hawaii for a year. So they're going to need a visa that allows them to do that and work while they're in the United States. And there's a lot of different types of employment-based non-immigrant visas. I'm sure a lot of you have heard of H-1Bs. A lot of you have probably heard of TN visas. It's specific for Canadian and Mexican nationals to access the United States. There's visas based on extraordinary ability, so that's something called the O visa, or an intra-company transferee, which is something called L. So there's a lot of different options, but for Canadian entrepreneurs or people who own their own companies, one of the best types of visas, and the one that I frequently work with, is called the E visa, and that's the one that is most relevant for this particular case study. So the E visa, there's two types. There's the E1 and the E2. The E1 is based on substantial trade by a Canadian company with the United States, and the E2 is based on a Canadian company or a Canadian investor making a substantial investment in a U.S. business. They are valid for 5 years. They're renewable indefinitely. It allows the primary applicant to work for the Canadian company while in the United States, and it allows spouses of the primary applicant to get derivative visas, which actually have unrestricted work authorization for the spouse in the U.S., which is really a rare benefit for a temporary visa in the United States. So they're a great option for people who are self-employed and they want to expand their own businesses to the U.S. Kids can also get derivative e-visas as long as they're under age 21. They can live in the U.S. and they can attend schools. So, this is what this family will be looking for based on their company's trade with the United States. That would be the qualifying basis for the company to apply to be registered, and then for the family members to get e-visas. As I mentioned, the non-immigrant visa option has typically a quicker timeline and a good option to facilitate a business expansion in a way that meets the immediate business needs and personal goals, but also leaves room for flexibility, just in the event that things change with the business or the family decides that they want to move back to Canada. And they also provide the flexibility to, for the family to continue living in Canada for, half the year, the full year, and enter as business requires, if if that's something they ended up wanting to do. As I mentioned, permanent residence for time purposes, I'm kind of limiting my conversation just today to the visas, the temporary visas. But that is something that people can explore at a later date. If they're living in the U.S., they like it, there's options, employment-based options for green cards as well. Another relevant kind of point for this particular case study is the grandparents or the parents of Kevin and Claire, Joe and Susan, who are also involved in the company, but just not as actively as Kevin and Claire. And Joe and Susan don't necessarily want to move permanently to the U.S., but they would like to be able to spend more time in the U.S. rather than maybe go to Hawaii for a couple months vacation and come back. So once you do have an e-visa company registration, you can apply for any employees who are executive, managerial, or essential. And so not only does it open up, ability for Joe and Susan to get e-visas, but any other employees of the company, of SecureCo in Canada, who are needed in the United States as well. And then if they did decide eventually to expand and incorporate a US entity, that could also work within the scope of their visa depending on how it was set up from a corporate structure. I will say in general, if it's a direct subsidiary of the e-visa named company in Canada, then typically the work authorization is for both the US and the Canadian companies. So I will leave it there for us to talk about the tax side of things, but that's a general overview of just the non-immigrant visa process.
Thanks. Hi, I'm Asif from Thorsteinssons. See, I can't say that. If you have an interesting drinking game around the name, I'll tell you about it afterwards. But yeah, welcome. Thanks for that overview, Hallie. That was really good. When I look at a fact pattern like this, there's just sort of a myriad of tax issues. Too many to canvas in a session like this, but to package it up from an issue spotting perspective, I think the best thing to do is to kind of look at it from the shareholder level and think of a basket of tax issues there, and then take a look at it at the corporate level and talk about the tax issues that arise when shareholders emigrate from Canada on the company. Okay, so there's sort of these two vantage points from a tax perspective that are highly relevant. So I'll start at the shareholder level. We've got the G2s, the second generation, the kids. The G2s are leaving Canada to go to the US. Presumably they've already gone through the immigration process and they're getting ready to leave. There's this question about where will they be tax resident. The fact pattern suggests they were sort of born and raised here, so they start off as Canadian tax residents. And the question is, when does that stop? When do they cease to be Canadian tax resident and commence to become US tax residents? Canadian tax residency is a very sticky concept. It's hard to wash off. You need to go somewhere else that also has a sticky regime and that we've entered into a tax treaty with. And US is a good jurisdiction for that because in our tax treaties with countries, we have tiebreaker tests to determine where you're more resident, and then you can be kicked out of the other place for residence purposes. So that doesn't work if you're going somewhere where we don't have a tax treaty, and that's usually all the fun tax havens out there. In those contexts, it's difficult to leave Canada from a tax perspective. But here our G2s are going to the States, so that's good. We know that jurisdiction well, and they would look to tie break to the U.S. under the tax treaty so that they could cease to be Canadian tax resident. And the easiest way for them to do that is to own a home there and not own one here. There's actually a bunch of tests, but that's the cleanest way. So assuming they've done that, there's this departure from Canada for tax purposes, and Canada imparts a departure tax on anybody who leaves Canada. It's similar to the death tax that Canada has when an individual in Canada dies. You're taxed on your worldwide assets for any unrealized gains that have accrued on them. So if you leave Canada, Canada says, well, you're not going to die here, so we'll tax you when you leave instead. So that same set of rules applies. Okay. So what the G2s in this context would want to do is get advice on what to do before they take off, so that they can deal with that tax exposure. We don't have a lot of facts around what they hold, but maybe they have a securities portfolio, some real estate, and we know they have private company shares. And there would be a gain recognized on all of those things if they do nothing. And in respect of their shares of the company, there'd be a gain there, and there'd be tax to pay. And then when the company makes distributions when they're in the U.S., they'll be taxed on that same value again. So there's actually a double tax that's built into the ownership of private company shares. It exists in every private company structure when someone leaves Canada or dies. Okay, so lots of planning goes into avoiding that double tax, and that's something that should certainly be flagged. One of the key things that we would suggest in a scenario where there might be a return to Canada is this concept of posting security for your departure tax. So if you leave Canada and there's a potential to return, you can calculate your departure tax, report your gains to the CRA, and provide them with adequate security instead of actually paying them the tax bill. You can pledge the shares of your company as security. You can let them lien a piece of real estate if you'd like, and it doesn't have to be the security could be on something other than where the gain arises. So we've seen situations where individuals have significant investment portfolios. I'm sure you've seen this in your practice, and the gain is over there, but it's hard to securitize these public company shares. So we've placed security on, a Whistler vacation home that's going to stay in the family forever, anyways. So it kind of puts that departure tax on the never pay plan, and if you return, you actually get your tax back and the security is lifted. Okay, so in this situation, we would highly recommend they go down that route until they're at least certain that they're not coming back. There's more to think about in terms of their departure. There's planning things you could think about, but I want to shift over to the company's side here, given our time allocation. But from the company's perspective, there's actually several material things that need to be thought about. It's not just G2s have to think about their tax and away we go. G1s can just ignore this and let their kids do what they want. If the owners of the company become non-resident, it has the potential to change the tax character of the company. Some might know of the term CCPC. It means Canadian Controlled Private Corporation. That is your sort of plain vanilla, ordinary private company owned by Canadian residents. Right now, SecureCo would be a CCPC, and all of our tax preferences for Canadian owners apply to those kinds of companies. They're the ones that earn the small business rate, 11% in BC. If you're not a CCPC, you don't get that small business rate. So anyone here who's professionally incorporated, you're in a CCPC. That's why you get a really good tax rate. If you're not a CCPC, then you're not going to get that rate. So that's sort of a key issue. And if G2s, we don't know the share ownership mix here, but if they control SecureCo, meaning they own more than 50%, and they leave Canada, that company ceases to be a Canadian controlled entity. It becomes a non-CCPC, and those special preferences fall away. And one of the key traps that we're seeing a lot of it right now with the volume of people moving their businesses to the States. It has some pretty significant effects for other really helpful exemptions that you can apply for. So there's a capital gains exemption that's available to Canadian resident individuals who sell shares of private companies. Most business owners try to get that at some point in their lives because it's sort of the one tax-free win you can get as a business owner. It's kind of like the principal residence exemption. Sell your shares of a private company, first $1 million or $1.25 million is tax-free. As soon as that company becomes a non-CCPC, none of the shareholders get it anymore. So while G2 might trigger their gains on the way out of Canada, at that moment in time it's still a CCPC. They can probably shelter a portion of their gains with their exemptions, but they just really screwed over their parents. because now their parents will never be able to claim the same exemption on their shares, okay, which ultimately will end up being their problem through the death tax regime. Okay? So this key issue needs to be thought about whenever a Canadian business the shareholders of a Canadian business are changing their jurisdiction. And there's all sorts of planning that you can do in advance to deal with that. Just a couple other quick issues, and use the cane if you need to pull me off the mic here. So distribution planning is affected by the migration of the shareholders. Dividends, they change shape once the shareholder is no longer resident. There's a withholding tax regime that applies to dividends. So now whenever Securico pays dividends to its shareholders, there'll have to be a withholding of some of the dividends, and that amount is paid to the Canadian government in advance, so that the Canadian government effectively gets a piece of the distribution. And then in the U.S. there'd be a foreign tax credit claim for the same. I know less about that than Shan, so I'll leave that alone. Another big issue here is transfer pricing. So, as soon as there's a related group of parties, so the company and related shareholders, and they live in different jurisdictions, they can no longer freely transact with that company on convenient terms, like interest-free loans, or how about I pay you nothing to live in that house, or these things all change. There's these rules that exist that require everyone transacts on fair market value terms, and that's so that Canada doesn't lose tax base to the U.S. and so the U.S. doesn't lose tax base to Canada. So it becomes very difficult to start transacting with the company. Everything has to be dealt with as though you're dealing at arm's length. So, shareholder loans change, services agreements between the principals and their company, if there's sort of a management agreement. All that stuff has to be thought about from a transfer pricing perspective. Otherwise, one jurisdiction or the other can impart tax for a less than or greater than fair market value deal. I'll just make a quick note on expansion considerations. We talked about that. I learned something through your presentation just now. There's often this choice between whether or not G2s would put a U.S. sub underneath the Canadian corporation, or instead incorporate sort of a sister entity, a sidecar. And if there's a lot that goes into that decision, and one of the key ones in this fact pattern are, do you think you're coming back or not? From a tax perspective, if you don't think you're coming back, we would say don't put that as a subsidiary under the CAN code. Although that might be not what you say. So now that I know that, I'll be more careful. But because what you end up with, if they're staying in the U.S. and you have a U.S. subsidiary with a Canadian parent and then U.S. shareholders, you kind of have a Canada sandwich, right? And there's a withholding tax regime on both sides. So you can't move money around anywhere without paying both governments. And it's highly inefficient to run a distribution through Canada and back out to the same jurisdiction. So instead we'd say, set up a sister company and do the U.S. expansion through that entity. It could have mom and dad as shareholders, and there's just going to be the non-resident issues on the U.S. side. And from a tax perspective, that would be neater and tidier. If they were going to come back, then that might not be our answer. As I said, there's many more issues, and there's a lot of rabbit holes that we could go down on those, but I'll leave it there and pass the mic.
Yeah, next, this is my favorite part. And my familiar part. And Shan's going to talk about the US,
Right.
But, yeah. Thank you, Asif first.
Thank you, Asif. Yeah. But I also want to point out how many people actually want to say that they will stay in the US, but then in the end they move back to Canada, right? So you can never know what happens. So that's why structuring planning is you really need to think about whether this person, stays in the US or, well, maybe they're just, after they stayed 3-4 years, they just suddenly think, no, I don't like you guys anymore. I want to move back to Canada. So when structuring businesses like that, you really need to think about these considerations. What happens they move back, and what happens they stay in the U.S. Now, from the personal perspective, there's a lot of materials here. I'll just focus on 3 key considerations when a client like this comes to us, moving, to the U.S. The very first one is definitely residency. As I've already covered a lot of nuances in there, that Canada focuses on residential ties and is very subjective. The U.S., though, it's very objective. It's the moment where you got your green card or you meet what's called the substantial presence test. And the substantial presence test is not like you spent 183 days in 1 year. It's actually count the 3 years in a row, even if you spent only 130 days in the U.S. in a year. By the 3rd year, you will be considered as a U.S. tax resident under this test. A lot of the snowbirds will face this, but there are ways to get out of that. One way is the closer connection, stating you have a closer connection in Canada and you spent less than 183 days in the U.S. in one given year. And the second we look at it will be the tax treaty. So there are a lot of situations where the taxpayer can be both a Canadian resident and a U.S. resident under their each domestic law. But then you will come to the treaty to tie-break which country gets to tax you as a resident. And you can't be a resident of both countries in general. As I've already mentioned how tie-break works, first one is the permanent hold, which is very easy to tie-break, but there are also some other, like habitual hold or some federal interest that can tie-break you to another country. And the last factor I'll mention, case law sometimes also works in favor, depending on your client situation. So that's why we say plan ahead, especially when you have a big transaction coming up. It may make sense for you to be a Canadian resident or a U.S. resident at that moment. So if you plan early, you can actually establish the fact that you make a bright line that you are a Canadian resident, for example, at that moment where the big transaction coming up. So the second one I'll mention is also departure tax, which is huge for Canadians moving out to other countries. There is already the options to defer. In our case study, it's relatively easier because we don't deal with U.S. property or U.S. citizens here. So if you elect to defer in Canada for deferral, the departure tax, on the U.S. side, in the first year, you need to make this election, basically saying that because I'm subject to Canadian departure tax, my cost basis of my properties got bumped up to the fair market value on the day I arrive in the U.S. If you don't make this election, the default rule is actually the original cost basis, which means you pay double the tax. You pay Canadian on the departure tax, but you also pay U.S. tax on it. There is potential double taxation problem though if you own a U.S. real property, because the U.S. gets to tax it first when you sell it, but then Canada also wants to tax it at the time of departure, and you can't really use the foreign tax credit if it's past 3 years you moved out of Canada. The same thing with U.S. citizens. I know it's not in our case study here, but I want to mention there. U.S. citizens also would face similar double taxation structures. That's why you need to very carefully planning the departure tax as well. One side note, if you moved into Canada less than 5 years and then moved out, only properties you purchased while as a Canadian resident is subject to the departure tax. It's not your worldwide assets if you don't live in Canada for more than 5 years, basically. The last point, spotting issues we would want to mention is the U.S. Introduced a whole series of anti-deferral rules under the Tax and Cap and Jobs Act in 2017. And it's put significant reporting obligations on individuals who control non-U.S. corporations. It's even complex than replicating the Canadian corporate return on your personal income tax return. So, and it doesn't matter like what type of business it is, what type of income it is, you're all facing like this reporting regime, and certain type of income is also taxable at the personal hands, even though you didn't take the money from the corporation, it's still taxable on the individual's hand. So one way to look at the structure of the company is also to consider that deemed income inclusion. So with all these departure tax and then the U.S. Deemed income inclusion rules, it's really encouraged you plan ahead. Like Kelly said, more than 6 months, preferably a year, to kind of looking at your overall objective, your business structure, and to figuring out what are the most tax efficient ways on the move to the U.S. So yeah, I'll leave it there. These three.
Just go ahead.
It's
very important to you.
Yeah, so I guess for my comments on this section, I think we really need to spend more time on the why. When we see a case study like this, it's always challenging. You never really want to hear someone say, well, I'm thinking about moving to the United States, but I don't know how long I want to spend there, and I might do this or that. I think that's a nightmare for all of us. Yeah. And I think, as professionals, it's very easy for us to get very focused on our solutions and kind of focus on our silos and saying, here's an advisory solution, here's an immigration solution. And it's hard for us to just step back and say, why are you going to Hawaii? I mean, we would never ask them, we would never interrogate them like this, but yeah, so why are you going to Hawaii? Why are you going to the United States? And then getting a better sense of what it means to try out living in the United States. Because, coming to the United States for a year, nothing we can work with. But if you come here for a few years and you get a green card, and then you decide to come back to Canada, that creates issues. If you decide to buy real estate in Hawaii and so on. So I think we need to get a better sense of what's the underlying objective here, and then we can be more in sync in terms of providing the most effective solutions. And then I guess on a family enterprise note, when I look at this case study, I say, well, the family has this very reasonable and noble goal of expanding the business into the United States. But from a family perspective, I say we have the first generation mom and dad that are aging, they're in their late 60s. And my question is what role will they play in the business over the next few years? You've got generation 2, Kevin and Claire. How long do they even want to be in the business? Are they going to work until they're in their 70s? So there's an exit strategy here. So I'm just concerned that maybe behind the scenes, maybe we're not giving enough consideration to family enterprise and the succession planning behind that, because if that's all done in Canada, it's going to be like what Asif mentioned. It's going to be Canadian structures, Canadian planning, and all of that. And as soon as some of these people start becoming U.S. persons, it's going to throw all of that into a big mess. So we need to ask those questions. I think I'm going to stop there for time. We'll move on.
Okay. Thank you.
I just want to add one really quick comment. The reason why we hold this collaborative partner events is also to meet with different people, because talk to different professionals.
Yeah.
So we work together. Because if the professionals don't talk to each other, it's likely that each of us has one piece of puzzle, and like no one knows the big picture and solution with it. Yeah. So yeah.
The team-based approach is the way to go.
Yeah, some clients, they will ask me, oh, I don't have any green card, I just live in the US, why I still need to pay tax? So, yeah. So, there's the immigration, some answers from the immigration lawyer, so, but it's different from the tax lawyer or the tax accounting. So, yeah.
Right, like the subsidiary example. Like I would say, this is what the visa requires to be authorized to work for this company, but Asa would say, this is what?
Crazy.
Exactly. And I don't know. So yeah, it's great to have the team and have everyone like on the same page and working and communicating with each other. So like Shan can put the pieces together.
Are we allowed to have a question right now?
Yeah.
Sure.
Yeah, sure.
Well, question's great. Wonderful. Well, first of all, thank you all. That's really informative. I do have a question. Thank you so much. Hi, my name is Ellen, and I actually practice also U.S. immigration law. And so in this fact pattern, there's just a couple of red flags, and I'm wondering from a tax or tariff perspective you might be able to address. So in this fact pattern, when we're using the E1 or E2 treaty trader, treaty investor, which is non-immigrant intent, there's also a visa called L, which is an intercompany transferee, which is a dual intent, meaning you may or may not stay in the U.S., and it's for an executive manager or someone who has specialized knowledge. So if they have their company in Canada and they want to expand in the US, there is a possibility for an L visa. If it's a new, they get 1 year, but if it's not a new L, once they set up their business, they can get up to 7 years, 5 years and 2 years, or if they're specialized knowledge. So everything is about intent. So if you were to go to the US and they said, well, maybe we want to stay and maybe we don't want to, if you went in as an E2, they would not get in, okay? Because they're like, your E is exactly for your business. And if you're telling me you're thinking you want to stay, that's in violation of a non-immigrant intent. So it's really important to focus on intent, where an L, which is an intercompany transferee, where you have a branch, subsidiary, or affiliate office in the US, is a dual intent. So if they said, well, maybe we want to stay, maybe we won't, that likely won't cause that same red flag. So I'm just warning, really important to pay attention to intent. And so we have the non-immigrant visa, we have the immigrant visa, but L is a dual intent. And also nicely under an L, a spouse can work anywhere, which is really nice. And sometimes the primary person might say, well, you know what, I want to do multiple things. And we look at the spouse to see maybe they have something they want to do, and then the primary becomes the secondary and can work for other organizations. So there's all, like what we were saying, all these really niche, unique situations. But the cautionary note is you don't want to go in as an E and say, like what you were saying, people don't know what they want to do. And if they say that, that is going to bar them for the US. And if they misrepresent, again, that is another bar. So just a cautionary note. My question about tax and tariffs. So now with the Trump administration, some companies, because of the tariffs, especially let's say with steel or other industries, are thinking that I'm losing a lot of money bringing my goods back and forth, and what Trump wants to do is incentivize people to set their businesses up in the US and then open the market, right? They're saying, well, I'm going to be in the US now, and I'm going to do a lot of trade. Now I'm going to expand my business, you know, into the US is an option. My question is also in terms of what are you saying, right? With this tax and tariffs, and if people want to follow the money, that's becoming an option for people to set up businesses in the US and to keep their trade in the US, so it keeps them away from the tax and tariffs. And the other part of the question, does it matter on a tax perspective whether dual intent or non-immigrant intent should matter? I know residency is where you physically live, so I'm sure that comes into the equation as well. So this just opens up some of the complexities of what you're looking at and how it's so important to really notice these red flags so that you don't put people in a, you know, a more sort of vulnerable position than they might be. So thank you.
Yeah, sure. Maybe there's some tax questions, so I'll start off. That works for everybody?
Yeah.
Okay, so great question regarding people currently trying to deal with the uncertainty caused by a cross-border tariff situation. So I'll just maybe use a story that I'm working with right now to illustrate it. So online retailer, Canadian-based, right, buys goods from all over the world and sells them online to different people in different jurisdictions, but it happens to be that a vast majority of their customers are in the U.S. So historically, they would just take possession of the inventories worldwide in Canada, ship them to the States, and it would have been fine. But under the tariff regime, that's no longer fine. It would be a tariff applied cross-border, and I'm not a tariff expert, so I just take that at face value. But the client's objective is to find a way to deal with this, and the advice they got was that they must set up a U.S. distributor. So this particular client has said, I understand these tariffs might not even be here in a month, but I have to do something now. Okay, and so to answer that question, what are we saying to people? I don't know. No, you know, like it's up to the client whether they think they can bear the risk to wait this thing out, or if they know in their business right now that they've got to make a change today. And this particular client felt have to make a change today, and worst case, they'll tear it down tomorrow. Okay, so in their case, what we did was we set up a U.S. entity. I think we ended up using a subsidiary in this case, but there's no migration involved. Nobody's leaving Canada to go run this thing. It's actually just a U.S. entity, and that comes with a slurry of Canadian tax issues, but none of them are as scary as tariffs. So we just did it, and what that entity does now is it fulfills the orders online, takes possession of inventories from overseas. There is a tariff that applies there, but at least there's not two tariffs that apply there, right? And now it sells into the U.S. market. So effectively, we segregated the business into U.S. and Canada. And as I say, there's all sorts of tax issues that arise. Like, is that a sale of part of the business to the U.S.? That could be a taxable event in Canada. Is this a licensing of Canadian IP? What is this? Is it just a distributor? Is there a services arrangement between the two of them? We've got a transfer price tag. Is it a cost plus arrangement? Like, what is this, right? So all those things start coming up, but I'll tell you, we're kind of dealing with it in real time right now, right? Because it's literally every week it's a different deal. And on the your other question was one that I forgot.
So if the dual intent versus
yes, that's a great question. So everybody comes to me when they're ready to leave Canada and tells me about their visas and their status in the other countries, and by and large we don't care. Okay, so you know it just, we do care in the sense that make sure you have status, because we don't want you coming back right after we put this plan in place, but nothing about that informs the intent to depart Canada from a tax perspective. Like, it can be a good factor if we can point to that document and say, look, they really meant it. They were going to stay there forever. They left Canada. But we've not, cases aren't decided on that factor. In fact, it's largely seen as a not relevant factor. They looked more to the factual dealings, the actual behavior of the individual. Where were you staying? Where's your toothbrush? How long were you gone? Like that, how often did you visit people here? Where's your mail? Where's your mail go? Where do you still have BC health coverage? Because that's not a good idea. Those sorts of things tend to be the indicia of intent that the CRA looks at.
Which could get a little tricky, I would think, with the L dual intent, because where is their residence? There might be in both. They might be living in the U.S. and...
But there's almost this acceptance in tax that people choose the status that helps them get into the country. And it's not as strong of an indicator of what their true intent is, right? So maybe people shouldn't do that. But there's almost this they used whatever visa they could get, and so let's look at the other factors to determine where they really are. That's what we see. Now, that doesn't mean that couldn't change at some point. And certainly when things are close to the line, when factors indicates both, Canada and non-Canada residents' intent, we would look at the visa and try to argue it our way if we thought it was helpful.
Right. And just a cautionary note there is that tax and immigration, one way might be beneficial for tax, but they can harm them in immigration. And that's
And for what it's worth, at least at our firm, we say never, do what works for immigration, because we can work with whatever status you get.
Yeah, perfect. Thank you so much.
No problem.
Just to add one quick thing too with the L, you summarized the intent issue very nicely, so thank you for doing that. The L does require that there is a U.S. company already in existence before the visa can be issued to petition for the person. So that's just something to keep in mind in terms of like one of those everything is so fact specific for each particular person, and it's super important. So like if that doesn't make sense from a business perspective now, but it will be the case, down the road, you can switch. So if you initially have an E and you don't have intent to stay in the United States, you have that year in Hawaii, and then you're going to reevaluate. You can incorporate in the U.S. and then if you were to want to pursue permanent residency and stay in the United States full time and have a path to citizenship, the L would be a really good option to switch to, because as Ellen said, it's dual intent, so you can simultaneously pursue a green card.
So just on that, the L could be a new visa where they can still give, the 1 year to make sure that business is running and then extend it. So they don't have to be in existence, but they have to be setting up the business, and then they'll check in a year and say, oh, if you're operating, then we can give you, another, so up to 7 years for executive and manager, so the 4-year and 3-year, or for the specialized knowledge up to 5 years. So if they're just starting to open it, you can do that, and that's why they give you the year look back. So it doesn't have to be fully running, it just has to be, initiated, and that's kind of that nice piece. So yeah.
Okay, thank you for all of the discussion, and it's very useful information. But next we are talking about if they are visa approved, and then they are going to move to the U.S. So what will happen after that? So we can talk about also from the immigration, if they need to have some paperwork before they enter the U.S., or if they need to change their investment portfolio when they become a U.S. resident, especially if they're holding any Canadian mutual fund in Canada, or if they need to structure their company when they become a resident, because if they become a resident, there's maybe more than 50% of the ownership, maybe they have a control foreign corporation, so there's another issue. So I will pass to you guys, and you continue to talk about this after they move to the U.S., what they need to do.
I can just be super quick. From an immigration perspective, it's very dependent. It's very fact dependent on the type of visa they are getting, what paperwork or what proof of this status that they must bring, and it also depends on kind of the process through which they're applying. So whether they're doing an application at the U.S. consulate in Canada, which would be like the E example, or sometimes through United States Citizenship and Immigration Services, which would be more in the L context, or a border application. If you're a Canadian citizen, you can apply at the border. So I think paperwork-wise, for once you're in the United States, it's important to make sure you're just keeping all the evidence of your status, whether that's an approval notice or the visa and your passport. But it would be too complicated to go into it, except for just based on the certain circumstances.
Johannes, how about you talk? Yeah.
I think. Are you okay for time?
No idea.
I don't know how to watch.
Okay. It's okay. I think
I'll
you
be
can
quick.
talk about it.
Yeah, so you're thinking of moving to the United States, and you've now moved into the United States. From an investment perspective, our first question is, where do you live? And then the second question is, who do you pay tax to? Right? Where are you a tax resident? So for this family, they're Canadian. Now they've established a residence of some type in the United States. They may or may not be U.S. persons, right? That might be TBD. But from our perspective, financial services regulation is dependent on the country in which you reside in, meaning you and the client. So Joe and Susan, they're Canadian They can work with a Canadian financial institution and Canadian regulator. Kevin and Claire would need to start working with someone who's licensed in the United States because their residency has changed. There's a number of nuances to that. It also affects what type of accounts you can open, what type of accounts you can maintain, and what types of institutions will keep your accounts. So that's that part of it. And then there's also cost basis tracking. So for the accountants in the room, we're definitely aware of that. And that's just that Canada tends to tax security transactions on an average cost basis. So total number of shares, total amount paid for it, and if you were to sell a portion of those shares, you take the average cost to determine your capital gain. In the United States, the standard approach generally is to use first in, first out, FIFO. And so that adds a layer of complexity because tracking in US dollars, and now you have to track lots. So you need to know what the purchase date is for every single security that you have. Because when you sell it, you're going to sell the first security of that type that you had purchased. So two different ways of tracking cost information. Most Canadian institutions are set up to track on an average cost basis, which usually leads to some conflict with accountants. Either someone's got to do the tracking, whether that's going to be a different Canadian company, your accountant, a bookkeeper, or someone else. But there is complexity there. We don't really have too much time to get into this, but treaty versus non-treaty states. So what that means is that not all states follow the Canada-US tax treaty. California is usually the biggest exception that we deal with. Hawaii is also a non-treaty state. And what that means is that the state doesn't recognize the treaty. So things that might be exempt from taxation, the state will say, no, we want to tax that. Common example would be RSPs. So RSPs, tax-free Canada, tax-free in treaty states. But Hawaii might want to tax the income or growth in your RSP account because you live there. So there's some planning that we can do around that, typically crystallization or portfolio changes to address that. And yeah, so that's a small piece on that. I also wanted to just quickly mention joint ownership. So generally in situations like this, not generally, sometimes the husband and wife don't move at the same time. So Claire might come here in August, go to Hawaii in August to get the kids set up for a school semester. Kevin might need to work on the business, work on the structuring, work on the expansion, so maybe he's working from Canada. So maybe he doesn't come later. I don't know if this messes up immigration, but it creates headaches for us from determining, if you have a joint investment portfolio of, 100 different securities, what's the cost for that? Is there a step up in cost? Is there a US cost basis? What are those? Do we need to split these accounts? Do we need an interim solution until they're both a resident in the United States? So just some things to consider. And then very quickly, if you're a US person, it generally means you don't want to own Canadian mutual funds. You don't want to own Canadian ETFs. Those would be the two biggest offenders. And also, I think it's important to consider residency issues. So in a situation like this, if you're setting up an investment portfolio and they move to the United States, you've done all this work to set them up in a good fashion there, we need to leave the door open that they might move back to Canada. And we just want to make sure that the investments that we're using are portable. You can move these investments between countries. We don't want to put clients in a situation where you're now forced to sell your Canadian investments because you moved to Hawaii, and then a year or two later, now you're forced to sell your new US investments because you decide to move back. So that's the short version.
Okay, thank you, Joanna. So Shan and Asif, do you want to provide any additional information after they move to the US?
Well, I guess in general, all the planning work should be done well ahead before you actually move to the US. And one caution I want to make here, the date of move isn't necessarily the date you departed Canada for tax purposes. It might be the date you sold your home, maybe the date your family all moved to Canada. It really depends on the specific client situations. whether you're type working with the tax treaty, using the tax treaty one way or the other. And we have seen clients talking to us, okay, I got my PR card, I need to file my Canadian taxes. And I asked, when did you move to Canada? It was like 2 or 3 years ago. It's like you never filed taxes when you're living in Canada. So immigration status is very different from the tax status. So I just want to caution on that. Yeah.
Okay. Should we just move to the Q&A section and maybe just ask
Yeah, I think we should.
one or two
Open the
questions?
floor maybe to.
Yeah.
Sure.
Yeah. So now we are in the Q&A section right now. Anyone welcome to ask us question and and you can.
Oh, I have one hand up there.
I have a loud voice, I probably don't even think. Okay. Hi, my name is Sonia. So I do a lot of cross-border individual tax, but I have a question about kind of cross-border corporate tax. So you have a situation where the Canadian residents are deemed to dispose of their corporation at fair market value. So let's say they have a capital gain, let's say they have a low cost basis. Is there a potential issue with double taxation? Because then the corporation may realize gains within the corp on assets that they sell, and then they also pay out dividends in the future and pay tax on that. So I know we often see this for terminal planning, but then you could do the pipeline and the loss carryback, but how do you deal with this for a immigration perspective? Thank you.
Yeah, so good. That's sort of squarely in my practice area. So we deal with this quite a lot. You tap into a major problem for private company owners. This double tax that I sort of alluded to earlier, you articulated better than me, so next year you're on the panel. It's just, the only reason I'm here is we gave you the venue, they wouldn't want that issue is a real problem, and in the post-mortem context, it's the same double tax, but it's easier to solve. We do it with a transaction called a pipeline transaction or a carryback plan in the post-mortem context, both of which you can't do as a non-resident.
Yeah.
So when this gain arises on departure, this question has to be answered. Will there be distributions of the same value while you are in the U.S., or do you expect to be coming back? If you expect to be coming back, then this double tax is largely theoretical. You would use the posting of security and you'd get it back at the end of the day. If you're going to stay there, then you've got to do some planning around this. And there are ways to trigger your gain before you leave and potentially attempt to extract the value from the company that way. It comes with risks. It's basically doing a pipeline plan before you leave Canada. There are risks around that, but sometimes there's no better option. For one of my clients who was going to the U.S. and there's a Canadian entity, what we did was just increase the overall tax to leave, but it was a marked decrease from the double tax that would otherwise have arisen, so somewhere in the middle. And what we did was we converted their private company to a ULC. It's a unlimited liability company. That's a invisible entity for U.S. tax purposes. So now it's as though from USC's shareholder just carrying on the business. We converted it to that and then let them leave, hit their gain. And then when they left, they restructured their ULC shares into another transparent entity in the U.S. called an S Corp. And then you could pay the dividend up to the S Corp and just hit your Canadian withholding tax. And from a U.S. perspective, they don't see that as a dividend because it's two physically transparent entities. So what it does is it goes a capital gains tax plus a 5% withholding tax, 30-ish%, much better than the 60-something you'd be at if you walked into the double tax. So if you know you're going to be there and you need to liquidate the value, that's a planning opportunity that you might explore. But as I say, it's sort of not a one-size-fits-all solution, and kind of got to see what's going on under the hood.
Yes.
Not an easy problem to solve. There's no like election to file and it's solved or anything like that.
Thank you.
About with security for CCPC. I had a client and Lodi tried once to try to get the security with CRA, and the client was not the majority shareholder.
Yeah.
And so is it basically a non-starter right there, because you have the CRA was insisting on all of these rules that the corporation had to do, but they were not a majority shareholder. So is that the end of the story?
That's a great question. I don't know the answer, but I'll just muse about it a little bit. I think any asset you own theoretically could be security for your departure tax. The problem in the private company context is that the security agreement places so many obligations on what the company can and can't do that it would be near impossible to get that agreement to be legally binding without the majority shareholder. So that's probably the issue your client ran into. But on its face, nothing about being a minority shareholder prevents that asset from being securitized. So it's sort of two separate things. Just practically speaking, it's just not a good securable asset from the CRA's perspective. They also barely understand how these things work. So dealing with them is a challenge. So it has to be comfortable, right? So it's much easier to attach to a piece of real estate or something like that.
Right. We also have clients run into that issue as a minority shareholder. We ended up posting real estates instead of
kind of
Canadian.
surprising to me.
Yeah.
I thought that the activity basically said that they must allow you to use your assets as security. So I thought, well, here they are. Take them as it is.
Interesting.
That did not work.
Yeah. Like it's they have to accept the securities agreement. So I guess it's one of those things that next time that happens, give us a call. Maybe we'll try it. Because you're right. Like if that's how it's said in the income tax act, it'd be fun to kind of see how far we could push from there.
Okay. Yeah. Thank you for our speakers for the fantastic insights today, and also thank you for your time and engagements today. So all we know, cross-border planning is complexity, and sometimes it's emotion. It's not just involved in like tax or professional planning. It's just but it's like family goal or long-term vision. So I hope this our section will help you guys have a sense to know where starting building the plan, instead just move to another country, instead telling to anyone and without doing any planning. And after that, when you find out, you cry to us, oh, I don't want to pay this huge tax. But you have to, sorry. But anyway, thank you for all you guys coming. And we still have the food outside and the drink, and help yourself. And if you have any question, want to discuss with this fantastic group, welcome to say hello and ask more questions for them. It's a free source to them.